Okay, so I'm not talking long-term management or long-term management funds. This is strictly short-term financial assurances, which are basically a mechanism to guarantee that a project is completed, and if necessary, that suitable resources, funds, are available to fix or replace unsuccessful projects. And this is a very long-standing practice in other contexts, in construction, in mining reclamation, landfill closure, hazardous waste remediation, and so forth. It's been adopted for use with compensatory mitigation. It goes back to the early 1990s as a mechanism associated with compensatory mitigation. And the idea behind financial assurances is the fact that mitigation projects are very complex. The outcome is uncertain. We've seen responsible parties fail or walk away. I think on ELI's website is an article that Roy Gardner and Teresa Pulley-Rodwan authored a number of years ago that is actually a series of case studies of what happens when mitigation banks go bankrupt. We saw a few of them in the 90s and the early aughts. Following the economic downturn of a few years ago, we saw a slew of additional bankruptcies. So there is perhaps a limited but real possibility that the responsible party may fail or the organization may dissolve. About 10 years ago, maybe a little more than that, there was a land trust in Southern California, the Environmental Trust, that was overextended. There were some questionable actions that were made in terms of funding for conservation easements, and ultimately they wound up entering into bankruptcy. And there are issues then of securing those conservation interests. So dealing with situations like that can be costly, and it's important to have an assurance on hand. You want to ensure that the mitigation obligation can be secured on the ground. What we're talking about then is risk management. We're talking about managing the risk that projects will not be completed, that the responsible party will not be there to ensure management of the project, that the project won't meet its performance standards. And this is basically the requirement for financial assurances in our regs. I know often the regs look very long and very daunting, but this one sentence is essentially the heart of it, that we, the Corps, must be highly confident that a mitigation project is going to be successfully completed, that it will meet its applicable performance standards. And that's the whole focus of financial assurances from our perspective. Now, going back to the idea of a responsible party being foreclosed on or undergoing bankruptcy, we were aware of, during the development, the drafting of the mitigation rule, that banks had gone under. And in some cases, the regulatory agencies, and in the cases I'm thinking of, it actually wasn't the Corps, it was state governments, sought to take action, sought to mobilize those short-term financial assurances. And lo and behold, they'd expired. So there was no source of funding to undertake remediation or corrective action. As a result, in our regs, there is the requirement that the Corps receive notification 120 days prior to the expiration or termination of the financial assurance. That's supposed to be in the plan, in the instrument, in the permit, in the actual financial assurance mechanism itself, to ensure that that sort of situation, or minimize the likelihood of that sort of situation taking place. Now, I want to contrast financial assurances with long-term management funding, because many people consider them part and parcel of the same thing. Under the mitigation rule, we consider them to be very distinct things. Financial assurances guarantee that a project is constructed, that it meets the performance standards. You hope that you will never have to make a claim on financial assurances. Long-term management funding is something different. They're resources that are actually drawn upon to manage that mitigation project once the performance standards have been met, and to ensure that a project is sustainable. So they're two very different things. One's a guarantee of performance, and the other is actually providing the resources so that project can be managed once those performance measures have been met. So in terms of posting those assurances, if what we're dealing with is permitting responsible mitigation, then it's prior to undertaking that permitted work in waters of the U.S. With mitigation banks, it's prior to the initial release of credits. In-lieu fee programs are a little bit different because they have two types of credits. They have advanced credits that are associated with a service area, but not with a particular piece of ground, a particular project. Those assurances or guarantees are basically built in the fee schedule, perhaps as one or more contingencies or sub-accounts that is accounting for a certain amount of risk or uncertainty. The other mechanism is where the in-lieu fee program is allocating resources or providing a guarantee for a specific project prior to project implementation. Now, there's also some alternative mechanisms, and we can talk about those as well. One would be a formal commitment by a government or public authority. We've also seen some piggybacking, what I call piggybacking or Me Too, where a regulatory body, could be the Corps, could be the state, will rely on financial assurances that are required by another entity to ensure that a project is completed. In other words, falling back on state or local government agency requirements for that project. So there's a number of approaches to establishing assurances. Probably the most common is a single assurance for the entire project. And it lasts the entire life of the project, from construction through that performance phase, that 5, 10, or even more years, where the project is being monitored to determine whether it's meeting its performance standards. A more common approach with larger projects, particularly mitigation banks, would be the use of multiple assurances. So you might see a construction assurance, resources set aside to guarantee construction completion of the project. And once construction is complete and the as-builts have been approved, it might be released. And another assurance would come into play, performance assurance. Some districts call that a monitoring and maintenance assurance. It's basically a guarantee that the project is monitored and maintained during that performance phase, that 5, 10, or more years, where it's being evaluated in terms of the project's satisfaction of ecological performance standards. A third mechanism is found certainly in the California core districts called interim assurances. And what this is something that is typically required after a project has met its performance standards, but before the project is going into long-term stewardship. And basically, it's a buffering practice. It's a practice to ensure that the long-term management funds have some opportunity to grow and generate earnings before they're drawn upon. The amount of financial assurances, as mitigation providers, it is your responsibility to determine that amount, but it is the regulator's responsibility to verify it. So really what you're talking about is determination of amount of assurance in consultation with one another. And it's obviously going to reflect the size and the complexity of the project, how far along the project is. Are you starting from scratch? Are you guaranteeing the entirety of the project, or has some level of work been done? Are there approved design or engineering plans? If there are, then an assurance covering that may not be necessary. You're going to look at the likelihood of success. Basically, you're evaluating the risk that something will go wrong, may go wrong, and evaluating uncertainty. We've already talked about full cost accounting, and this extends to the amount of financial assurances. It should be based on the full cost of providing mitigation. In some circumstances, then, it could include land costs. We'll talk about that later. And some of these other elements. Now, here's a sample construction assurance estimate, and you probably can't read it, and it's not really important. This is an example from a real compensatory mitigation project. Actually, this is a project that was implemented in eastern North Carolina. And it's not important what the dollar amounts are. What is important is that the engineer broke the project down into its component elements, and from that point was able to assign specific costs for it. So it's not a number that's pulled out of the air or whole cloth. Considerable thought went into identifying what needed to be done for this wetland and stream project. So they talked about construction survey, as-built survey, temporary construction, entrance, grading, invasive species control, and so on. They broke the project down into its component elements. And this is a very useful approach for evaluating or even determining the amount of financial assurances. Now, there's two basic mechanisms for determining an amount of assurance. One would be based on on-site remediation. The other is off-site replacement. On-site remediation is basically the cost to complete the work and meet performance standards, and it doesn't include land costs. It presumes then that you have a high likelihood of that project meeting performance standards. Again, it's the mitigation provider, the sponsor's responsibility to provide component cost estimates. It's the regulator's requirement then to verify it. And there's a number of sources of information that can be used to verify those costs. In-house engineering estimates. All core districts have a cost engineering section that could be drawn upon to provide assistance in that review. We're actually working on a pilot right now with Jacksonville District on that very effort to look at feasibility and how we can streamline that process. Another approach that has been used by a number of districts, particularly if it's a new form of compensatory mitigation, if it's something new that they don't have experience with, is requiring independent third-party evaluation of the plan and the amount of financial assurances. You could look at similar project costs in the area. You could utilize software applications. Center for Natural Lands Management's proprietary property analysis record could be used for something of that nature. Later on today, Angela Sturdivant with TNC is going to talk about their stewardship calculator, and arguably as a tool that could be used as well to evaluate financial assurances amounts. If you're basing your assurance amounts on on-site repair, on-site remediation, this is a valid approach only if you have no concerns at all regarding the quality of the site and the surrounding landscape. If you have any uncertainties that adjoining land use activities could negatively affect the compensation site, or that the compensation site could negatively affect adjoining lands, such as through increased flooding, then maybe this is not an approach for you. If there are questions of ownership or access to the property, in many cases, at least with conventional assurances, performance bonds, letters of credit, there's a designee that is going to receive those funds, and for that party to be appropriate, they've got to have access to the property. And they've got to be willing to undertake the work at that project site. So if you can't answer any of these affirmatively, this is probably not the approach you want to use for determining the amount of financial assurances. So instead, you might predicate it on off-site replacement. This is the cost of compensation at an alternative site by a third party. This is much higher. It includes land costs, in addition to other project development costs. It's not considering any costs that have already been sunk into that existing project. What you're basically saying is that the current site does not have the potential for meeting mitigation objectives. Now, you could use the similar sources of information as on-site remediation for your financial assurances, but what a number of districts have done have been to predicate the amount of assurance on what it would cost to replace compensation through the use of third-party compensation, either another in lieu fee program or mitigation bank, if that's available. A couple of different approaches that have been used by in lieu fee programs as financial assurances. We've seen a number of in lieu fee programs. For example, Mississippi Coastal in lieu fee program, Kentucky Fish and Wildlife Resources, for some projects have used conventional assurances, performance bonds, letters of credit. A more common mechanism is where the in lieu fee program is actually providing a self-assurance. They're setting aside resources to guarantee completion or remediation of the project. Virginia Aquatic Resource Trust Fund is one program that has done this very effectively. We've also seen, in some circumstances, alternative mechanisms. The best case of this is North Carolina Division of Mitigation Services. I don't know whether ELI has posted NCDMS's instrument on their webpage, but one of the associated documents is a very interesting letter from the director of North Carolina Department of Environment and Natural Resources to the Army Corps of Engineers Wilmington District, providing a guarantee of project performance, that they will provide the necessary compensatory mitigation to offset the mitigation obligations they take on. Well, at the time the instrument was proposed back in 2010, the program had already implemented hundreds of mitigation projects. They're a known quantity. They have performed. The whole focus of financial assurances is to ensure that we are highly confident that a project or projects will be completed and will meet their performance standards. And so that written guarantee alone was determined sufficient, that additional financial assurances would not be required. You may also deal with projects implemented by state-sponsored in lieu fees where they may not have the legal wherewithal to post financial assurances. We certainly see that with many departments of transportation. Perhaps on the downside, on the other side, they're continually issuing permits. It's in their best interest to continue to comply, or they're looking at the possibility of affecting permitting. I want to just bring up one point related to federal fiscal law. It's something called miscellaneous receipt statute. It basically says federal agencies cannot receive non-federal funds, nor can they direct the use of non-federal funds without specific congressional authorization. What this means is we can't make a claim on a letter of credit unless we've got a designee, somebody that we've identified that can receive the funds and develop an appropriate plan. If we take the funds, we are obligated under law to deposit it in the Treasury. And we all know that means that money is not going to be put on the ground in compensatory mitigation. So we need that designee, somebody to receive the funds. Now, ELI has posted on their website a memo from Headquarters Corps Office of Counsel to offices of counsel in all the Corps districts on financial assurances, and one section of it deals with miscellaneous receipts. And it talks about what is called indirect receipt or constructive receipt. And the idea is that if we direct expenditure of funds, we are violating the miscellaneous receipt statute. We are in constructive receipt. And those aren't our monies. They're not federal monies. We don't have the authority to direct the disbursement. But Office of Counsel came up or identified a way forward. While we can't direct the disbursement, we can review and approve plans. And those plans may have associated with them or may entail expenditure of those monies. So we can't direct the expenditure, but we can approve plans that by definition entail the expenditure. Okay, do we have time for any questions?
Questions? Thank you, Steve. Okay.
Yeah.
So, Seattle District does this a little differently. We don't have a third-party designee explicitly chosen, but the way our ILOCs or LOCs are worded says we won't give it to a third party.
And a number of other districts have done that as well. They basically have an assignment agreement associated with the letter of credit. And at the time a claim is made, many of the letters of credit even specify that there will be no payout to the court, to the identified beneficiary, and that instead immediately that assignment agreement will be completed and filed. And obviously, counsel in those districts have thought that through and are comfortable that it's consistent with federal fiscal law. And that's something that district councils are going to have to reach on their own.
But the term direct the funds, right, in this last bullet we have here, throughout the federal rule, it clearly says the DE can direct funds.
Right, and the long and the short of it is, council's interpretation, this memo was issued in 2011, several years after the mitigation rule. Now, when the mitigation rule was developed, it was coordinated with the Office of Counsel. For whatever reason, they didn't catch or they weren't concerned with that language. They are concerned now. I don't think anybody necessarily wants to open up regulations for revision. But I would definitely defer to what Headquarters Office of Counsel has to say on financial assurances.
Well, I get that all the time.
And if you go into the preamble, if you go into the preamble as it relates to financial assurances, they make extensive mention of miscellaneous receipt statute. They just are not establishing the linkage associated with constructive receipt, indirect receipt. Michael.
I know that a couple of years ago, the idea of credit insurance was looking to gain traction, and there were two different major underwriters. I know some core districts were receptive to the idea, and others were not. Can you tell me where that might be?
Okay, so the question is, correct me if I'm wrong, you mean casualty insurance?
Yes, but the policy specifically say replacement of the credits that would not be delivered.
Yes, okay, so casualty insurance policies have been developed for compensatory mitigation. 13 core districts have approved their use either for mitigation banks or for permitted responsible mitigation. In the event that a claim was made, there are a number of options that are available. One would be purchase of replacement credits. One option might be site remediation, or basically whatever the regulatory bodies that are making a claim on that policy deem is most appropriate. So we've got 13 districts that have approved them right now for 35 mitigation banks, 8 permittee responsible projects. Some of the permittee responsible projects are really, really big in Texas. There's a bit of a flux right now. There are 2 companies that are working policies. Part of the challenge is finding underwriters, and there have been some fluxes in underwriters. What we've got out there right now is roughly about $100 million in coverage. And this is an area that I think we're going to see grow. But the determination as to what an appropriate financial assurance mechanism is left by the mitigation rule to the individual districts. Financial assurances, like real estate protection, are driven in large part by state laws. What is acceptable in one state may not be acceptable in another state. A number of districts have expressed concern about the ability to make claims on these policies. Other districts have felt that the likelihood of success was so high that the amount of risk, relatively speaking, was very manageable. And it's all about risk management.
I'll take you, but Palmer does have questions.
My question is about casualty insurance. So far we haven't seen that restored, right?
No, we haven't seen casualty insurance proposed by any in lieu fee programs.
We allow it from full delivery providers into the financial. The letter from our secretary that you mentioned, we just pass that on and cover ourselves with providers, and we do allow them to use that insurance, but they're still trying to get the floor to be more receptive.
So Michael Ellison has provided an important clarification. While the letter, the guarantee of performance by Division of Mitigation Services is out there, they are, correct me if I'm wrong, still requiring under full delivery projects the mitigation provider to provide the appropriate bonding or financial guarantee of performance, correct?
Yes, we would be advocating our fiduciary responsibility if we just left the state with this open liability to perform. That would not be good risk management on our part.
Agreed. So Michael has indicated that to do otherwise would be abdicating their fiduciary responsibility, their obligation associated with the mitigation obligation that they took on when they agreed to provide compensation for those permitted impacts.
We will accept it from, and it's not just what we're all our other mechanisms. We will accept it, but the provider has to get approval from the court. And there's, we haven't used it yet because the court and the people selling the insurance and the service providers who would like to use the insurance, they have not all gotten together. There's a lot of reticence from the court. No one's ever really made a major claim that we know about. And if you're talking, $10, $50 million project that's never been through claims process, some people are a little concerned.
So by way of clarification, Michael has indicated that NCDMS would certainly be willing to consider full delivery mitigation providers utilizing casualty insurance as a guarantee. That has not yet been approved for specific projects by the Corps of Engineers. And there is the question related to casualty insurance for compensatory mitigation of claims made. We just don't have that experience as of yet with claims made on the policy and the potential outcome of those claims. There is a certain amount of uncertainty in terms of the claims adjustment process, how long it might take, and so on.
Devin?
Yeah, kind of related to all that. Do you have any data, or is there anyone tracking the use of these financial assurances, saying how many failures have there been that have required the...
I don't know. All right, so the question is anybody tracking claims on financial assurances? Arguably, it could be done on a district-by-district basis. I've been looking at administrative performance of compensatory mitigation for about 12 years now, and had gone back and looked through the records. Since the 1990s, I've come up with no more than 24 instances across the country where claims have been made on assurances, either permitting responsible mitigation banks or in lieu fee projects, and the outcome is very uneven. Some cases the obligations were successfully secured. Some cases they weren't. We do touch on some of that in the IWR Financial Assurances White Paper. We issued an update earlier this year, and there are a couple of examples there.
That's posted on the website too. One last question.
The risk isn't incurred until credit sold, correct? To offset it.
Pardon me?
There's not a risk for the project until a credit is sold to offset it.
Okay, so the question that Ken Powell had is that the risk is not there until a credit is sold. Technically, the risk is really not there until a credit is released.
Yeah, release. So is there any consideration to collecting it at the time the credit are released rather than?
We actually have seen a number of districts that have done that. And in fact, under the mitigation rule, generally credits are not released until the financial assurance has been posted, and there are a number of banks around the country that have sought to forego financial assurances by foregoing release of credits until part or all of the project has met performance standards.
Thank you, Steve.
Thank you.
Okay, wow.
Thanks. I just want to add one quick thing on insurance. I used to work in Superfund Financial Assurance at EPA, and we had, I think, only one example of an insurance policy that was posted as financial assurance that we actually did draw upon. But that was over 10 years ago, and the insurance landscape has certainly changed a lot since then. And I think from what we've seen, underwriters want to stay away from open-ended liability, right? And environmental cleanups or compensatory mitigation could be in the category of open-ended liability. It's not really traditional construction. So I'm not too optimistic about insurance products coming online in the near future for financial assurances for compensatory mitigation. But, you know, it could happen. So anyway, for what it's worth. Anyway, my name is Bob Pullen. I work at the National Fish and Wildlife Foundation. I was going to talk today a little bit about financial assurance from the perspective of a sponsor, a little bit about the foundation, if you guys aren't familiar with us. We are a congressionally chartered nonprofit. Now, what does that mean? We were established by Congress in 1984 to support the efforts of the Fish and Wildlife Service. We are not part of the federal government. We're independent, but we now work with all agencies. So our mission is really to support the work that the agencies are doing. So before we talk about the sponsor's perspective on financial assurance, I think it's important to look at sort of the big picture and ask yourself, you know, why are you here? Why are you sponsoring an ILF? As a state agency or a nonprofit, it's really essential that you understand why you're doing this, because it's likely very different from your traditional activities. If you're a state agency, are you trying to fill a void to serve a state interest? We've heard some folks talking about this. Maybe there's an inadequate supply of mitigation in your state for projects, or even for the state's own projects, you know, big transportation projects or things like that require mitigation. If you're a nonprofit, why do you want to be a sponsor? Does the activities of sponsoring an ILF serve the core mission of your nonprofit? You really need to understand these questions, and you should be doing this because you have a commitment to conservation, not because you're looking to make profit. There's nothing wrong with profit, and your ILF should certainly run in the black, but profit really shouldn't be a motivator. And maybe this is a topic for a different panel or something, but you could make an argument that there is no profit in an ILF, or there shouldn't be for a nonprofit, because the money stays trapped in the system. So it's really just going to go towards more conservation in the future. So anyway, it's important to just have this backdrop, because issues are going to arise as a sponsor that are new to your organization, and they're issues that you're not used to dealing with, and you just need to be prepared to that so you can be in a position to deliver rule-compliant mitigation. So the first big question is, why do we need financial assurance? The short and simple answer is that the 2008 rule requires it. But even if it wasn't required, sponsors should want financial assurance. As we've talked about, and as you all know, the sponsor stands in the shoes of the permittee and is responsible to deliver compensatory mitigation. This is a big deal. Liability transfers are a very big deal, and you can't really overstate how important and significant this is. This is likely outside of the traditional role of a nonprofit. You're probably not usually a permittee. You're not on the hook for compensatory mitigation. You're usually doing good works, or you're a grant maker, or things like that. And it's a very different mindset, and you need to be aware of the responsibility and liability that you chewed off and that you're now on the hook to deliver. So what is the point of financial assurance, and why is it required? As a regulator, you might view financial assurance as a guarantee that a project is constructed or meets certain construction milestones or performance standards. As a permittee, you probably view financial assurance as a necessary cost of doing business. However, as a sponsor, you should view financial assurance as a welcome protection. Financial assurance should not be thought of by a sponsor as a cost or a burden. Rather, it's an essential tool to help protect you. It's something you can use to limit your financial risk. And again, the cost of this should be sort of irrelevant to that calculation, because the cost is really passed on to the purchaser of the credits. So it's not even coming out of your cost or your bottom line, not that that should be your top priority, but it's really not a cost of your organization anyway. It's built into your credit price. So how can an ILF provide financial assurance? Steve talked about this in his presentation. ILFs can provide traditional financial assurance mechanisms, bonds, letters of credits, cash escrow accounts, things of that nature. Or they can provide a form of self-assurance or self-insurance through a contingency fund to address their potential construction shortfalls. However, we need not think of this as an either-or situation, and it's likely prudent for an ILF sponsor to provide both tiers of financial insurance. So to have a contingency fund and some form of self-assurance, and to also require or put in place some forms of traditional financial assurance. So we're going to talk a little bit about contingency funds first. Basically, a contingency fund is a reserve of money set aside to cover possible unforeseen future expenses. And maybe they're foreseen, but possible future expenses. Again, it's a form of self-assurance. If you're using a contingency fund to provide your financial assurance, then a contingency component should be built into your credit price. And this can happen many ways, and hopefully after this, my sort of brief presentation, we can talk about this with the other providers and the IRTs to see what they're seeing. But this might often be expressed as a percentage of your base credit price. So maybe 10% or 30% or a sliding scale, whatever it might be of your credit price, you figure out, okay, some percentage of that is going to be for my contingency. So you tack that on when you're building your total credit price. And that's your contingency amount that you're putting into your contingency fund. Now these funds collected are put into a contingency sub-account where they're pooled and commingled. So they're not tied to one specific credit sale or one specific project, but rather they support the entire, I guess it could be service area wide, but usually the entire program. So you have a contingency fund that's going to support any project in your program that needs a little help. It might be prudent. These funds could be capped, so you might not be paying into your contingency fund forever and grow this sort of massive amount. I think our cap in California is capped at $3 million. That's not an insignificant number, and hopefully regulators are comfortable with some form of cap. That means there's $3 million in place to help any project. And if money is drawn down or ever spent, of course, it's then replenished. And again, if you ever run into a situation with a project where it looks like you're going to have a financial assurance triggering event, or you're going to be drawing upon your contingency account, or even worse, it looks like something might drain your account and put your program even in some sort of financial jeopardy, you need to talk to the IRT. and you need to talk to them before you're at that last stage. You should talk to them all the time as part of your monthly calls or whatever it might be, an emergency call. But the IRT is absolutely your friend in most cases, but especially when it comes to financial assurance, because your interests are 100% aligned. So the contingency fund is just one layer of financial assurance, but it doesn't have to be your only layer. Often the ILF sponsor is not the work party who's building mitigation on the ground. Usually, not usually, but often that party, the sponsor might have an ILF or some other selection process to find a mitigation party to do the work. And the ILF should require that the sponsor should require that work party to post financial assurance for the work that it's agreed to undertake. So for us at NIFWIP, we don't have boots on the ground. We don't build mitigation. But when we collect enough funds in a service area to trigger our project threshold, we would hold an RFP or find some other way to select a mitigation provider, enter into an agreement with them to build a mitigation, and we would require them to post financial assurance. So now we have two layers of financial assurance. We have our contingency fund, but before we tap that, there's the provider has posted financial assurance. And again, this protects the sponsor and provides the regulator with greater certainty in an uncertain world that a project will be constructed as contemplated. So this is really my last slide, and I was hoping we could have a discussion, but once you establish your contingency account, you're not finished. It's something you've modeled and you've built and you think it's going to work well and you hope you have enough funds in there, but you really don't know if it's adequate. Is it big enough? Is the right piece of your price going towards it? Is your cap appropriate? Only time and experience are going to let you know if you've sized it right and modeled it correctly. At the first sign of any inadequacy in the size of your financial assurance or the method or the means or any aspect of your financial assurance, you need to check in with the IRT. Again, I said this on the last slide, but your interests are 100% aligned here, and you need to check with them right away to figure out how to address this so you don't have a shortfall and so your FA is adequate. And this might mean an adjustment to your credit price or to the component of your credit price that goes towards your contingency. But you should be doing this anyway with the IRT. Prices will be revisited. Prices might be a little high when an ILF is new because the ILF provider is uncertain what these costs are going to be, and they need to make sure that they can cover the costs, one, so they remain financially viable, but two, also so they're not subsidizing mitigation. So as part of the review process, you should be thinking about the financial assurance and its adequacy, and hopefully that's addressed all the time and stays sort of current and relevant. So that was sort of where I ended, and I wanted to leave a lot of time for discussion because I'm curious, and of course ask me all the questions you want, but I'm curious what other ILFs are doing out there for financial assurance and what the IRTs are seeing. And if, in fact, you are seeing contingency funds, I'm curious about the percentage or how that was modeled to the extent people are willing to share, if there are caps or anything else. So with that, I'll sort of open it up.
Thank you, Bob. So anyone want to start with that? Anyone have experience to share?
All right.
No one? Data?
I'll offer some.
Data person and Gail.
I can just say what Oregon does. So we are limited by our Oregon state statute. We can't open-ended say we're going to do an obligation with funds available. So we do have a contingency fund. We designate 30% of every credit sale to the contingency funds, and so we revisit that annually to look at how many credits have been sold and if that fund is adequate. If not, we'll move funds over until it is. We do keep track by project just because different projects are at different stages and the risk lessens as you move on. Once it's constructed, there's a release, for example, once we meet our 5-year performance standards, there's a release. So we keep track by projects. So it's a combination of total number of credits sold, and what stage each individual project is in. We haven't had that much experience. We did have one project that drew on that, but so far so good.
Gail?
So yeah, we have a separate sub-account for contingencies. It's 10% of the credit fee, but again, our credit fees are so high that our people's like 30% of theirs. Those are pooled per service area. We also have stipulation in our instruments that says the interest earned on the account gets divided between the long-term management account and the contingency account.
Right.
So that's constantly growing. We haven't thought about a limit or a cap, but we might want to do that since we are amending our instruments. But we get so we wouldn't ask a county or a nonprofit to traditional financial assurance like a letter of credit.
Right.
So we get what we call a political promise. And the way we did, like King County actually passed an ordinance that says, hey, if we run short, we will go to our council and ask for more money. It's not guaranteed. We can't make them do that. Well, we built that political promise and how that works into our instruments. And we required the counties to pass ordinances to address that or write us a political promise letter. For our banks, we only allow letters of credit. And my experience over my 20 years in banking is the threat of cashing in an ILF is enough to get the sponsors right on track very quickly. We've never had to do anything but threaten. And, usually threatening to suspend their credits is enough. But you threaten to go into that huge ILF, and they're like, what do you want? I'll do anything. So,
Yeah, and one thing I'd quickly add about letter of credits or traditional financial assurance, if you have a bond or something, make sure you know where it is and that it's in a secure place.
oh, it's yes.
Because when I worked at EPA, one of the things we did, one of the things that I did with a friend of mine a friend of a colleague, is we had to assess the Superfund financial assurance portfolio. So we had to reach out to all the regional offices, look at each Superfund settlement and see where the financial assurance instrument was. Nobody knew where anything was. We had expired letters of credit in someone's drawer, if you could even find anything. Standby trusts that were written with RCRA authorization language, but here we're under CERCLA, so you could never actually trigger them. So there were all kinds of issues. So I would say make sure you know where it is, and like you said, it's in a fireproof safe or something else, because it is cash, right?
Okay.
I wanted to ask about preservation sites and what, if any other programs, what they do for financial assurance for preservation. And also, if the new Land Trust Alliance Terra Firma insurance program might be sufficient for financial assurances for preservation sites. That's been up and running for just a couple of years now.
Steve, did you want to comment on that?
I'm willing to comment on the idea of financial assurances for preservation sites. I'd say yes, they are appropriate. In many cases, what you want to look at is what activities are associated with establishing that preservation site. Maybe not in Alaska, but certainly in parts of the lower 48. There may be fencing associated with it. There may be gates, issues of access, signage, legal rights of way. All of that might entail establishment of assurance, and as well as potential monitoring. Now, maybe that's handled by the easement holder. Maybe it's handled by the landowner. But some sort of financial assurance to guarantee those activities are done should be provided.
Any comment on that terra firma question? Thoughts? I think Devin and then.
Well, I was wondering, you have a cap on your contingency fund, and a certain percentage of your credit sales go into that fund. So what happens when you reach that cap? Do you reduce your credit prices?
Right. I mean, I think we'd have to revisit that when it happens, because $3 million is still a pretty high threshold. But one answer is that you wouldn't reduce your price immediately, but that would stay in the program account or in the service area account for which those funds were collected, and they would continue to serve, in a sense, as some sort of financial assurance, but they wouldn't be in the contingency account. But if you did reach a point where you were collecting too much and all of your accounts really, had too much money in them, you'd have to talk to the IRT about that and see if a credit price adjustment was in order.
I'm wondering, Gail, the contingency accounts that are established as part of the credit sale price, you said it's 10%. Those funds that go into a separate sub-account, do those similarly require approval for disbursement, or how do you handle accessing?
So if somebody were to wanting to access, yes, they would have to submit a spending dispersal agreement, and the IRT would have to approve it. It's the way our instruments are written. I'm going to look into Virginia's. I think it's very interesting that the requirement for the spending disbursement is handled through the instrument, and that they don't have to do it. I mean, for some projects, we're seeing 2, 3, 4 spending dispersal agreements. Each one is very detailed and complex and requires a budget analysis now. So it's a lot of work. So if we can consolidate that process, that would be great. So I'm going to look into that.
Other questions? Palmer.
Yeah, I have a follow-up question for Dave. So can you tell us a little bit about the Line Insurance Program and what it was actually designed to do? It might make sense.
Yeah, it's a program that was developed over the past 5+ years, where they were trying to get a critical mass of land trusts or other conservation easement holders who want to buy into this program so they have enough funds to provide it. And for $60 a year for a conservation easement, it's an insurance policy against violations or provide funds for going to court to uphold the conservation easement. So it's specific to conservation easements, $60 a year. And there are, like any insurance policy, it has some exclusions, but it has been used now by a number of land trusts and has been successful at upholding conservation easements where a large lawsuit might have the long-term management or the stewardship funds for that conservation easement. So it's an added protection. Our organization does both. We don't see it as replacing a stewardship fund, but we actually add that cost, that $60 a year to it. The cost of a stewardship fund, but it looks promising.
Any other questions before we go to break?